Good evening. This is a special meeting of the Portsmouth Planning Board, March 30th. Most of the members are here. Mr. Franco's not here. Jane Bedell will not be here. Peter Harris is running a few minutes late. So we have the first half hour of tonight discussion with the board, as everybody I'm sure saw. So if anybody has any issues they'd like to talk about, we've talked about possibly having some additional workshop meetings. And if we do have workshop meetings, we might have them down on the floor at the same level as everybody else. So if anybody has anything they'd like to bring up for conversation.
Rick, so I went to the governance committee meeting on Monday, and the chair of that committee was proposing work sessions for 5 city councilors, which seemed a little odd, but I think I'd like to see us do things like that so we can at least explain, ask questions of each other for clarity before we get to a meeting, and that way it doesn't drag the meetings out as long as sometimes they get dragged out.
You know, the reason Beverly and I talked about this a little bit, we thought we'd have a few minutes tonight, is just because we started conversations really late at night, which is a really difficult time to have those conversations. Mm-hmm. And if people don't have things they'd like to talk about, that's fine. But I thought it would be better at 6 o'clock than 11:30 at night. So, Jim?
These are just kind of a laundry list I came up with. I'm not so sure they're for work sessions or these are like goals I have for the planning board to, like I said, discuss in a non-planning board type setting. And the first one is looking at ways we can improve the CIP, make it more clear and comprehensive. I'd like to see if Portsmouth can look around to some other communities for impact fees. I know Dover has a long-established impact fee program. I'm also interested in revising our butter notification procedures because I think they're not advantageous to butters, and I know other towns give a lot more time and material in their butter notifications. I'm also curious about the North End Vision Plan and how it was developed in 2014 or 15, and how that relates to what's being built out there now. That kind of covers my quick list.
Just a quick question, the butter notification, do you think there's a problem with the statutory notification or just?
Well, I know that you can increase the radius of abutters. Mm-hmm. Different towns, I've seen 200 feet, I've seen 1,000 feet. I think Portsmouth could look into that aspect of it.
Okay.
I know timing. I know some towns give much longer advance notice times to abutters and what material they include in their notifications. Things like that.
Andrew?
Being newer, I think for myself personally, it would be advantageous either to understand better the scope of a design review proposal or break out the design review proposals into smaller portions. The most recent example being Mark McNabb's project on Congress Street, and trying to understand the different components of that development. Oftentimes there's a lot to digest in that, whether it's circulation and traffic or actual design or just end use of a certain property. Definitely not for some of the smaller ones, but some of those more pivotal downtown, Deer Street, North End type vision plans. I feel as though if we had a more focused design review, the developer could walk away with better feedback on individual pieces and then come back to us again for one more comprehensive review. And then I guess even prior to that, if there was an additional either site walk or ability to understand their intent with the development, and maybe how they see their ability panning out. So whether it's based on zoning or just development scheme, saying we have the developer explain to us what is going on and what they see happening, and maybe we can provide more informal feedback, and then they propose to us additional changes and whatnot. Again, it's just, the idea is to break it down into smaller sections, then they're easily digestible.
I know from your background, you might have seen more of an interactive discussion on design.
Yeah, and I think from that experience, definitely, we often would engage in more conversational type dialogue. And I understand how there are formalities to this board, but even before it gets to the lectern, there could be an opportunity to incorporate that into our planning board's ability and inviting other commissions or boards to those types of meetings. And I'm sure Beth has more experience on that.
No, I just wanted to add that we've actually done that in the past, but we haven't done it as a board to create that. It's actually been the developer who's asked for work sessions.
Yeah.
Like we did for, I believe it was West End Yards. We did like almost a year and a half of work sessions before we ever saw a site plan. So that we got to, and we kept telling them, no, we want this, and they'd come back and we'd keep going back and forth. So there is the possibility of doing that. I just don't know, I'm not aware or remember any situation where we've requested that. It's usually been the development that's come to the city and said, we'd really like to talk about these things in some work sessions well before we ever, get into actual formal review.
And if I could chime in on that, oftentimes a developer will come to those types of meetings with an idea in their head based on either prior experience, an economic equation, so a math equation that says they need to get X amount of units or square footage. And so with that knowledge in mind for us, it would be super helpful to then understand that metric or understand that perspective. And it may be something that we actually propose to them. That way, the prevailing conversation and dynamic is not something of, this is what we want to do and let's go, and then we just interject our feedback. It's more of a blend, and if that's something that the planning board can engage with, because oftentimes, and again, I'm newer here, but we see a lot of the same developers over and over again, which is awesome, and I think keeping it local is the primary principle here. But we are very familiar with these types of developers a lot of the time, so it could be more attainable than a larger city or anywhere else. So that could be an opportunity, I think, to have it, even if we didn't have the entire board, but maybe a quorum to go and attend or walk the site, sit down with their architects, sit down with their team to better understand the end goal.
Makes sense to me. I mean, I don't know how.
And I know people are busy and
I
have a lot of
agree,
stuff
a
to
more
do.
hands-on approach by the planning board than just, if they create, what he just said, if they say they want 70 units, and they go, great guns, setting up a plan with 70 units, but if they would have talked to us at the beginning and said, we don't see it, could have saved a month
Yeah.
in their process and our process.
The technical advisory committee certainly has an initial review, but they're more focused on literally the technical details of the project. And I think we could consider threshold, so project of a certain size, or perhaps project in a certain location would get this more of an interactive. I think it would help the developers too, because by the time they came to the formal presentation, we'd be more all on the same page and understand what the issues are.
They'd be thankful that they didn't waste the time and money doing something that we weren't going to look at.
How does the board generally feel about that?
Yeah, I think it's a good idea, yeah.
That's healthy.
Andrew, you had more?
Yeah, just super brief. It could even be like a thesis of their development or a development strategy that they want to pitch to us, like a headline that they're going to bring to us. And then from there, everything else, again, is broken out into smaller portions. And so it doesn't need to be a full-scale, full-blown review. Just maybe, hey, this is our thesis, this is our concept. How do we feel about that?
Executive summary, using
Yeah.
another.
Because oftentimes you can discern what they want to do, and this finer pieces, obviously, we would get into on a more formal level.
And Councilor Moreau, when you had the West End Yards project going, were there things, elements of that you found useful, the actual process?
Most of our conversations were around how many units they were going to have and how many workforce housing units we were going to get out of it. And it was, they actually presented with us with lots of figures and lots of details as to what they could financially make work and give us workforce housing units. So it started as a 350 unit project and ended at 250. So you can see there was a big swing between the start of the project and where it ended up. But I'll tell you a story around where design review started, because we didn't actually have either preconceptual design or design review on the books when I started on the planning board back in 2013. There was a project that is now built, and this was really just a road. So you know the new road that's off of Borthwick Ave, where they built a big commercial building out there? They were proposing that road at the beginning, and we never really saw it at the beginning, and they spent like a year working with the city, coming up with this plan to build this giant bridge to go over the railroad tracks so that they could stay out of the wetland buffer. And the planning board got it, and we hated it for a whole numerous amount of reasons. Needless to say, that didn't go over well with staff or with a whole host of people. The end result was, okay, maybe the planning board should start seeing these projects at the beginning before a ton of money's poured into them. And that's where this whole concept of us looking at things early came from. The end result of that is they did not build the bridge. They ended up with a road and mitigated some of going into some of the buffer in order, because we were worried about all of the migrating animals and all the stuff that bridge looked like a really imposing figure. I mean, we had a whole host of reasons, but that was one. We got sued, the whole 9 yards. So, I mean, we had a really bad experience, and that's where that came from. And I certainly agree that there could be expanded on. I go back to the first Harbor Corps that we looked at. I mean, we not only spent work sessions talking to them on multiple, but that project was so large that we actually broke it into 2 nights. We did truly half of the site plan on one night and half of the site plan on another night. And it was the only thing we heard. And we were here till 1 a.m. for half of that project because there was so much interest. So on these larger projects, it is a good idea to really try to break them down and really have some hard conversations in a work session kind of with them. So I believe in it. We've done it in the past. Where it starts or how we get there, I'm not sure.
So if I might, I just want to, because I'd like to figure out a way to kind of get you where you'd like to go with this. And so I'm just trying to understand, like, would it be appropriate at the time when we're doing preliminary conceptual to really, if at that point, say, when this comes back to us, we're particularly interested in these topics and we'd like these to be covered. I do want to direct the planning board to design review phase requirements that are in the site plan regulations, which do limit the purview of some of it, or what they need to submit as part of that. Traffic studies are not usually part of that. But proposed uses, I can provide that list to you so that you know. But is there a point either during the completeness check or during the preliminary conceptual where we might be a little more structured in our feedback and ask the developer to, we're particularly interested in these components. We'd like you to be prepared to discuss the following, and the board can, because I think we do offer general comments about, well, we're not super excited about this feature and we'd like to see more of this. But maybe if the board can come to a consensus about the types of things that they would like the developer to focus on and give that kind of feedback, and the chair can invite that kind of scrutiny, and the developer can respond by providing some more detailed information about those things that the board's particularly interested in.
I think you could have two methods. You could have one where the regulation was modified a little bit so that it was automatic of a certain threshold. You don't automatically get into it. Or you could have, with some discretion at the pre-app discussion stage, to say, these aspects of this project, we would like to have some design review, some additional design review conversations.
I can send those regulations, just so they're 2.4.3 in the site plan regulations, but I can send a summary of that to the planning board members.
And, and I think if anything, if you were to engage with this developer sooner rather than later, they may still have a couple iterations where there are a combination of different factors included in each iteration. And so by the time either we're at our site review or preliminary review, we can actually hold both of those in our hand and see the difference and see why a certain aspect was changed. And then there's an explanation to follow, providing that, hey, this is why this was the result. And then us as the planning board can say, well, that's very constructive, thank you. And now we know where they're coming from, and we know how they have arrived at this certain outcome or this result.
How they responded to it. Did anybody over on this side? You guys are good
For right now, yeah.
for right now? And Peter Harris has joined us. He came in.
It's all right.
That's okay. Okay, go ahead, Andrew.
Yes, very succinctly. What about post-project reviews
How do you mean?
Yeah.
upon completion? So design review of West End Yards or design review of X, Y, or Z project?
I think that would be educational for the planning board. I don't know that we can require it, and we can't even go on somebody's property without their permission. So,
You mean that badge doesn't get me anywhere I want to go?
No, it'll,
But what we can do, I think, if it's agreeable to the chair, is that we do have a presentation, hopefully in April, depending on how the schedule shakes out. We'll know it probably in the next day or two. We do have Vincent Hayes coming to talk to the planning board about the post-entitlement process, including his flow chart, how he takes the stipulations and he matches that against the construction plans that come in. He satisfies all the things that are precedent to the building permit, and he checks to, and he also follows up during the course of the project. It would not be inappropriate in the future for the board to, just to request a follow-up, like, where's this at? I think getting into a lot of the enforcement of stipulations might be, a lot of detail, but definitely, I think it is a useful exercise for, just out of your own interest. It's certainly something that in the previous jurisdiction I served in, that we would have follow-up saying, hey, just a summary of what's going on right now out there. Here's all the projects that are nearing completion. This is probably 2 months out from certificate of occupancy. This item is, just pulled their, framing permits, but we've got all the silt fencing. Just some general feedback about larger projects that might be of interest. And we can definitely follow up. And I think that the board will have a higher level of confidence once you hear from Mr. Hayes about his process and how closely he works with legal, public works, the building official, and planning staff to understand the stipulations and enforce those to meet the intent of the planning board.
Yeah, and I mentioned meeting with him at the last meeting, and I think there's a good process the city has for technical compliance, but maybe I misunderstood your comment, Andrew. I thought you might be looking for the board to learn from projects that were built.
Yes, and my anecdote would be Councilor Moreau has been on this board for 9 years, and she's seen projects go from design phases all the way to completion and now maturity and stabilization in our city. So someone like that has experience and knowledge of how a project unfolds, not only over the course of 6 months to a year, but much longer. And so having that ability to look back on a certain either zone or a certain ordinance that we have controlled and enacted to say, here's what the intent of this ordinance was, and here's how this actually played out. And if there are any amendments or less formal changes that we need to make, that we can actually understand why those are relevant and how those can be applied to future developments.
Okay, I get it. Jim?
Yeah, along the lines of Vincent Hayes and his job to assure things are done right, does every project we approve have a surety bond? Does the developer have to put up money in pretty much every one?
Most of them do.
It's my understanding that most of them do.
And
Most of the projects that have site plan review have site plan agreement and a bond associated with them to make sure that all the conditions are met and that the project is completed and not left sort of half developed. So yes.
Is that based on a percent of the construction cost, or how's the?
So I would have to follow up with you on that, about how they arrive at that. I believe that there is input from legal and from also Public Works about some of that information. I don't know how they come to the, do you know the answer to that, board member Paluso? Do you know? Yeah. Mhm.
They typically, the contractor or the developer typically provides us with an estimate, and we review that. And, in most cases, if we have to adjust things, we discuss it with them, if we think it's adequate. But that's how it starts. They provide us with an estimate, and we review that to see if it meets our standards of construction.
Is the bond for the entire construction amount, or is it for a percentage?
It's usually for the infrastructure,
Okay,
yeah,
the public infrastructure,
public or private infrastructure.
or private, okay,
You know, if it's a private development, not the buildings.
right.
But the infrastructure and utilities and drainage.
So the bond, can I talk to him?
Yeah,
So for the full cost.
So the bond is just related to improvements that will be Portsmouth property in the future. Is that true?
No, it's the entire, even if it's a private road, we still will take a bond. to make sure
Okay.
that it's complete.
But in general, it's for infrastructure and not buildings.
Correct.
Okay.
any other, I know Andrew mentioned site visit, anybody? Well, before we get on site visits, there was a discussion about workshop. Is the board in favor of the idea of having workshop meetings? If we can keep them relatively brief, and, okay, we'll try to figure that out.
Sometimes you can just do a half hour before a meeting starts or an hour before a meeting starts, and that way it's all in one night. I used to find that was quite helpful, so that you weren't having to come a different night as well.
I agree with that, yeah. That was nice when we used to do that.
I knew we could get you to speak up if we.
Trying.
So just so I understand, is the purpose of the workshop, we would have it before, would it be to just for general discussion about the upcoming agenda, or would it be for other administrative type topics, or all of the above?
Sometimes it would be based off of zoning that we were reviewing. So if we had, like when we did the ADU laws, we had many work sessions looking at different iterations, and then we'd give feedback, and then we'd decide how many times we needed to keep coming back till we had something we thought we could go to a public hearing with, and then send it to city council. So that was one of the things. We used to do it sometimes with projects if they were larger projects. We did it a lot with, like, when we were writing a master plan, we had a lot of work sessions around that. And any training that the board would want, we'd have work session format to do all of those types of meetings.
Understood.
Does anybody know, because I don't off the top of my head, Jim mentioned the North End Vision Plan, is that a part of the master plan?
It was part of the zoning that we enacted when we did form-based zoning in North End. That's when the vision plan was created. I believe that parts of that were taken into consideration when the master plan was written. Because I believe the North End zoning was changed before the master plan was written, if I remember correctly.
Yeah, I believe it's a separate document.
Yeah, it was a separate document, but obviously that idea and those concepts were part of the visioning of the master plan.
So as the Land Use Committee starts to develop ideas, it might feed into work sessions that we could have in advance of a regular meeting, that sort of a thing. We could also talk about changes to site plan, which could possibly add this additional design review steps we talked about earlier.
Yep.
We have about 5 minutes. I'm going to be very mindful of Attorney Buckley's time, so if anybody has anything else.
Move on.
I think we can. I think we can start 5 minutes early with you, Attorney Buckley, if that's. Absolutely. Thank you very much for coming this evening.
For having me. Good evening. My name is Steve Buckley. I'm Legal Services Counsel for the New Hampshire Municipal Association, and I'm also legal counsel to all of our members, the 234 members of the New Hampshire Municipal Association, which certainly includes the city of Portsmouth. My job at NHMA is to give legal advice. 60% of my time is on the phone, answering emails, and providing assistance to our members. The other thing I do is this type of training program to give direct assistance and information to public bodies, planning boards, zoning boards of adjustment. And so tonight, I'm going to be presenting, my own way of encapsulating the basic roles and responsibilities of the planning board. But I've also incorporated some elements that deal with the right to know law and some of the issues that board members face with regards to conflicts of interest, interacting with the public, applicants, et cetera. And so I expect, and I imagine you'll have questions as we go through, and I think you should go ahead and ask me those questions. But the presentation, as indicated, starts with the right to know law, and then I'll also segue into some of the relationships you have with applicants, the duty to assist, and the difference between quasi-judicial and legislative actions by a public body, and some issues with regarding to avoiding conflicts of interest. And then I make a presentation on some of the basic principles of what the planning board does, subdivision, site plan, some of the key statutes that I think are important for boards to be aware of, workforce housing, capital improvement planning, which may not be really a topic that your board spends a lot of time, your particular board spends a lot of time on it. You might have a separate CIP committee. I'm not sure exactly how the city organizes the CIP process, but certainly the planning board oftentimes has input to that. Zoning amendments, innovative land use control issues, streets, driveways, merged lots. And then I spend the balance of the presentation on procedure. You know, what are the steps for a preliminary review, getting an application, the timeline for review, third-party consultants, it's developments of regional impact. That was a matter that the chairman wanted me to address. And then making the decision and relevant considerations as you go through the decision-making process. And then a little bit on appeals. Certainly worthwhile discussing the fact we have this new entity, cop on the block, so to speak, the Housing Appeals Board, which has the power to address appeals that deal with housing or housing development, which is a new wrinkle to how your decisions might become the subject of review beyond the point of your final decision. So next slide, please. So I always start with the right to know law because I think it's fundamental. I mean, I've actually used a corny example that it kind of surrounds everything and touches and concerns all elements how public bodies operate. But I can't underestimate the importance of the right to know law and how it kind of gives you a sense of how you participate in decision-making and how the public is allowed to have access to the processes you go through in deciding whether to approve or deny a site plan or a subdivision. I think the key thing to understand about the right to know law, it comes from our Constitution. So there's a constitutional requirement that government be open, accessible, and accountable. And that requirement is then brought into the right to know law statute, 91-A. And because it's a constitutional right, the Supreme Court jealously guards and gives great attention to cases arising under the right to know law. So we always have to be very careful to turn very square corners to comply with the right to know law. And I think the key thing to understand about the statute, and it's the preface of the statute, is that the right to know law is intended to give the maximum public access to the actions, discussions, and records of public bodies. And that's one thing that I think oftentimes public bodies have a hard time sometimes grasping. It's not just when you're making a decision. It's when you're discussing matters within your jurisdiction. I mean, I just today had to make sure a member of a public body was aware that the discussions that were being carried on by him and other members of the planning board via email that preceded a public meeting were substantive discussions. No decisions were being made, but they were substantive discussions. And the public has a right to know when and how and where those discussions are taking place. And when it takes place on email, the public can't see what's going on. And they can't see your thought process. And that's kind of a critical understanding for the public to have. As I indicate, the statute requires the greatest public access to the actions, discussions, and records of public bodies. Next slide, please. You'll pardon my, I've been on the phone all day, so I pardon that my voice is a little creaky. That's why I actually had to borrow some money from your planner to get a bottle of water. I apologize to her. So it's important, especially with regards to as a public body, to understand what the right to know law requires for public meetings. And that requires you to first understand, what is a public meeting? Well, it's always a quorum of a public body defined by statute, or even could be an advisory board created by the planning board, that convenes so that they can communicate contemporaneously, discuss or act upon something over which the public body has jurisdiction. So anything that the planning board has jurisdiction over, where you're convening through a quorum, and you're a board of 9, correct? So 5 members present, you're a quorum. And if that quorum is discussing matters within your jurisdiction, that's a public meeting. And there are some fundamental requirements for complying with the public meeting elements of the right to know law. The public has to be given 24-hour notice at public meetings. The public has a right to attend, and you as a public body have to create minutes of that public meeting. Next slide, please. This slide just reemphasizes what is a public body, and it's broadly construed. It's all legislative body, governing body, board, commission, committee, et cetera, et cetera. But I think the key thing to understand is a subsection that deals with the fact that any subcommittee or advisory committee to the planning board. So when I was on the planning board, as a further introduction, I was on my planning board in my town for 12 years. I'm currently on the zoning board of adjustment. We created a subcommittee to help rewrite our master plan. That subcommittee had to do all of the necessary requirements of notice and opportunity for the public to attend and keeping minutes. So any of your subcommittees that you might create, any advisory committees, those are all subject to this requirement of notice, attendance, and keeping minutes. Next slide, please. So the convening element, so it convenes such that all participating members communicate with each other contemporaneously. That can happen in person, obviously, but it could also happen by email. And it could also happen by telephone conference. And so one has to be very cautious, in my view, to avoid having a quorum of the planning board on the same email where they can those members can communicate with each other, or they can hit that deadly button in your email program, the reply all. That is the deadly button, because you hit that reply all. Now you've created an opportunity for all the members to begin having a discussion on matters within your jurisdiction. That doesn't mean you don't use email, but I think the better practice, we always recommend that email to a quorum of the public body be sent from staff and be sent using the blind CC method, so that when staff sends it to you, all the email addresses of the recipients of the board are in the BCC line. So that if I get the email, this is how I get my emails from the people who manage the zoning board in my town. I get the email. If I hit reply all, it's just going to go back to the staff person. It is not going to be distributed to the rest of the planning board members, or in my case, zoning board members. And again, I think we just emphasize the fact that it's to discuss any business of the planning board, and it could be construed broadly. However, I would also say this. There are going to be occasions, and this was certainly true in my planning board, where we had an occasion to be together, but it wasn't a public meeting. So in my planning board, we had a Christmas party every year in December at the home of the chairman. That was a meeting that was not designed to discuss public business. It was a social occasion, and certainly one could do that. But that's the exception, not the rule. Next slide, please. Just re-emphasizing the electronic communication piece. We really have to ensure, as many of our members are aware, that you have to avoid substantive discussions by email. This doesn't mean if a planning board member wishes to communicate to the chair or staff that they want an agenda item added, they can say, can you add this agenda item? Not to discuss the agenda item, but to add it. Or, I can't come to the meeting tonight because my kid is sick, or whatever the case may be. Those are administrative, not substantive discussions. Those are permissible forms of communication. But I think that the key thing that's important about the statute that touches this issue is RSA 91-A:2-A, which was actually added to the statute in 2009. And the key element is, and I'll just read it to you, communications outside of a meeting, including but not limited to sequential communication among members of a public body, shall not be used to circumvent the spirit and purpose of this chapter as expressed in 91A. So what that tells us is, if you have two members of the planning board who've had a discussion, which is okay, but then they say, okay, well, let's go talk to these two other members. And so you send the email to the two other members and then further discuss our conversation. And then they send another email to the other two members. Pretty soon you have that very sequential conversation, which I think the statute really says is inappropriate. So I think we always encourage a great deal of caution with electronic communications using email. You can use email, but as much as possible, use them through staff, and using the blind CC delivery method is really what we recommend. Next slide, please. I added this slide just to sort of emphasize some of the general standards that the Supreme Court, which also, I would say, also comes from the New Hampshire Constitution, that planning boards have an obligation under our Constitution to assist the citizens in navigating the complex, which they are, complex zoning and planning regulations which exist in most communities. And because ultimately what the court's view is, the subdivision and site plan process is not intended to be completely adversarial. It is intended to be a process whereby, the owners of property have the ability to execute a use of their land consistent with your regulations. And in part, that comes from the fact that, and this is, I'm judging back to my days in law school, zoning is in derogation of the common law right to do what you want with your land. So that was really something that came about during the 20th century. Euclid versus Ambler versus Euclid Realty was the case that brought about zoning and was deemed constitutional by the U.S. Supreme Court. But it was always recognized, and that was one of the things I learned in law school from land use, that zoning is in derogation of the common law right to use your land as you see fit. And so, generally speaking, zoning and regulations should be viewed in the light most favorable to the ability of property owners to use their property. And I think that just fits into the duty to assist and recognize that planning boards have some obligation to assist the applicants and work with them so they can attempt eventually to resolve concerns and ultimately get a permit approved so they can use their property consistent with their right to do so under the rules and regulations that you have. Next slide, please. It's also important to understand and appreciate the different forms of decision-making a planning board has and participates in. And these are really divided into two separate areas. There is the legislative decision-making that you might make, and then there's the quasi-judicial decision-making. Well, let's just start with the quasi-judicial, just a fancy word of saying you act in a manner similar to what a judge does. You hear evidence, you hear opposing points of view from a plaintiff and a defendant, from an applicant and a abutter, and then you, based on the evidence you receive and the testimony from the applicant and the abutters, you render judgments. And in the case of a planning board, that's either approval or disapproval or an approval with conditions. So it's very much like the decision-making process a judge has to go through. Taking that into account, there's a higher level of necessity that those who act in a quasi-judicial capacity do so in a manner that ensures fairness to all concerned and is as much as possible free from prejudgment and free from decision-making which is not based on the evidence that is presented at public hearings and is available for all to see and understand, oh, this is how the board reached its decision. These were the engineering reports, this was the testimony, these were the regulations upon which the board made its decision. To be compared with legislative decision-making, where there's a much greater latitude for your own biases to be present and to be used in order to inform your decision-making. And I think the best example of that is when the planning board might be considering master plan changes. You certainly have a right as a member of the planning board to bring your own point of view. What is your vision for your city? And that's an important part of your role. And that's certainly the reason why in New Hampshire we rely on volunteers. We are relying on your knowledge of your community to inform that which is going to eventually turn into your master plan or a master plan update or revision. So as a consequence, you have much greater ability to bring to bear your personal point of view when you're acting in a legislative capacity. Next slide, please. The statute which really governs the manner in which you have to be cognizant of a potential for conflict of interest is RSA 673:14. I think there's a couple of key phrases in the statute. Members of the planning board, when you're acting at a quasi-judicial capacity, when you are, approving or perhaps disapproving a site plan, and I gather that most of your activities in the site plan realm. I imagine, as I understand it, most of the lots in Portsmouth have been built out. There's not a lot of subdivisions taking place. So when you're making decisions with regards to site plans, you do have to ensure you do know how to have a personal or pecuniary interest. Now, personal interest would be the applicant's my brother-in-law or a relative. Pecuniary interest, the applicant is my employer, and if my employer gets the approval, I'm going to get a raise. It's very easy to understand. But then it gets a little bit more detailed. But actually, one other thing I want to mention, a member is not disqualified for any cause to act as a juror upon the trial of the same matter. So if he would be disqualified, if you have a disqualification similar to if you were being asked to sit on a jury, I don't know if you've ever had this wonderful opportunity to be a member of a jury. I've never done it. I've picked juries before, and I've seen a lot of processes where juries get picked. And the way it works is each member of the petit jury is asked a series of questions to determine whether or not they would have a disqualifying reason for not sitting on that particular case. And what the court asks, next slide please, are these questions. Do you expect to gain or lose? Are you related to either party? Have you advised or assisted any party? Have you directly or indirectly given your opinion? Are you employed or employ any person or party in the case? Are you prejudiced in any degree? And do you employ counsel appearing in the case? These are the questions that the jury is asked.
Gonna have to stay at the microphone because it's being recorded.
I'm sorry. Yeah, sorry. So those are the things that a juror would be asked, and it's similar to what you're kind of being required to take into account. To what degree would I have a need to recuse myself and not sit on a jury on a particular case? And I think the most important one is probably prejudgment, to avoid any sense of prejudgment. Next slide, please. I want to mention two cases that I think bear on this issue. The first is the Robert Foley trustee versus Enfield case. Interesting case because what happened was the matter was pending before a zoning board of adjustment. And before there was a final decision on a motion for rehearing, whether to grant or deny a motion for rehearing, after a hearing had been concluded, the chair of the zoning board of adjustment decided to post an inquiry on, I'm sure you may be familiar with the listserv managed by the Office of Planning and Development, also previously known as the Office of Strategic Initiatives. And so what he was trying to inquire as to whether or not, what are the standards that apply when you're trying to determine if a board can take into account cumulative impact of various activities, land use activities. And he posted this message. Mind you, the case was still pending before the ZBA, but he made this kind of separate inquiry and got some replies. And then the next day, they eventually decided the case and denied the rehearing. The applicant was aggrieved, of course, didn't like that he didn't get his relief, and he appealed to the Supreme Court. But before the matter was heard by the Supreme Court, he learned that there was this, I guess you would say, ex parte contact. I'm not sure it's really considered ex parte, but it was a form of information gathering by the chairman outside the hearing process. And it was alleged by the applicant, well, wait a minute, I'm supposed to know what's going on. How can this information gathering be taking place and there's a decision-making process going on and I have no ability to respond? Ultimately, the Supreme Court said, well, we don't think you've really shown prejudice. And it has something to do with how the vote came out and how this was not a particularly material issue. But I think it's fair to say that the Foley case does suggest that in the right case, if there had been a member of a planning board who gathered information outside the hearing process and then used that either directly or surreptitiously to form a decision, that could have a bearing on whether or not that's an appropriate exercise of quasi-judicial authority and could, put in jeopardy a decision. And the biggest problem we face, and it's one thing that I always, and I'll talk about this in terms of conflicts of interest, if you believe that you might have a conflict or a prejudgment, one of the things you don't want to do is to stay in and make a decision anyway, participate in the vote. Because if it's decided you later on should have recused yourself, the whole decision is thrown out. You don't just subtract out that person's vote. It's deemed to have infected the entire decision-making process. And the worst part about that is, if you've handled an application that went on for months, and now it goes to the Supreme Court and it comes back, you're going to subject all your fellow board members to have to do it all over again. And that's disheartening, I think, for volunteers to feel like, oh my God, I got to do this all over again and listen to all those people in the room. And so it's just something to keep in mind. That's why I think the Foley case has some importance. Next slide, please. The other one I think is important is the Z1
Buckley?
Express case. And this one involved.
Excuse me, Mr. Buckley?
Yeah.
Are you taking questions now, or should we wait?
Anytime, yeah, go ahead.
All right, I have a question on ex parte communication. So far, I like to be knowledgeable about the sites that I'm going to be voting on, so on the weekend, I go out and visit properties, I walk around, I get a feel for the situation that, that's being presented. Is that ex parte communication?
No.
But it's gathering information outside the planning board.
Right, and ideally, what I would encourage board members is to say that I visited the property on this date at the next public hearing and voice and explain what was observed. I mean, ideally, I think when we're talking about site visits, I think site visits should be done as a board. I know that's what we do on our ZBA. That's what we did on our planning board. We would all go to the site visit at the same time. So everyone was there at the same time. We all heard the same information from the applicant, and hopefully if the abutters there, they have a chance to say a few words, so that we can all hear and see what is eventually going to be a basis of information from the site visit that might have an impact on your decision making. So I think that's the better practice, but if you are going to a site in between meetings, I think it would be wise at the next meeting after the site visit is say, well, I visited the property and this is what I saw. So I think, again, as fairness to the applicant, so they know, what is the basis of knowledge that you're using to make a decision.
Thank you.
So the Z1 case is a really interesting case, because this is a situation where the planning board in Manchester was wrestling with a conditional use permit, and it had to do with whether or not a gas station be built in a residential area, and there was a whole furor and website set up by those who were opposed, who were abutters to the new gas station. What happened is, while the application was pending, two members of the planning board, one who actually was an alderman member of the planning board, actually posted messages on the abutters website saying, we're with you, we oppose this project. And then at the meeting when the planning board was going to make a final decision, wisely, the applicant's attorney said, hey, Mr. Alderman, you did this, and we think you should recuse yourself. And he was given the opportunity to recuse himself, and he didn't. He went ahead and voted. He voted no. And of course, they appealed. The Superior Court judge says the alderman did not enter the decision-making process with an open mind, and that was improper. And the decision was undone. They have to do it all over again. I don't know if the gas station was ever built, but I think the point I would make is, stay off social media. It's just, there's nothing to be gained. To be posting things on social media, or to going to social media, or being a friend on a website that deals with a pending application, it's just going to necessarily enmesh you in circumstances which could put in jeopardy an argument, or could jeopardize your ability to have, to make a fair decision, or someone could accuse you have prejudgment. So the Z1 case, I think, is important, because what I just tell people is, and what I did a couple of years ago, I got off all social media. I'm not on Instagram, I'm not on Twitter, I'm not on Metaverse. It doesn't do me any good, to be on it. That's why I think the Z1 case is worthy of merit and note. Next slide. And so when we're dealing with conflicts of interest, you have a couple of choices. Under 673.14, you can ask your fellow board members, I want your input. Should I recuse myself here? Whether it's a potential relationship issue to an applicant, or whether or not you've arguably formed a prejudgment, you can ask your fellow board members, do you think I should recuse myself? And take heed of what they advise you. A board member can do it, a board member can say, I think we should take a vote on whether or not this member is recused or should recuse themselves. So you can use that as a basis for making a decision to recuse yourself from a particular matter. I just would say, though, just so you know, the applicant can't ask for an advisory vote on recusal, and neither can anyone else. Only board members can do that. So it's reserved for your ability to form a sound decision. Is this something I should not vote on? I've already mentioned social media rules. Again, the main takeaway I have with these issues, if it is in doubt, if there's some concern, you have some doubt in your mind, should you recuse yourself? Just recuse yourself. You've got, I would assume, alternates who can sit, and so you've got 9 board members, so even if you lost 1 or 2, you still have a quorum and you can make a decision. And I think that's just the better practice, err on the side of caution and recuse. Next slide, please. So the rest of the presentation is really about planning board fundamentals, the planning board statutes that are most common of concern and attention, and then the procedure. But before I get into that, I thought I'd just stop and see if there was any questions about conflicts and the right to know law before I moved on. Yes?
Can you just be a little bit clearer? I guess I'm a little bit confused when you talk about the duty to assist, because you don't really want to be discussing a project with an applicant prior to them actually being heard in a public forum. So you're talking about sort of the narrow line of the process of how to go through it, but not the substance of the actual project.
Well, I guess I would say this. I encourage all boards to liberally use conceptual consultation. That is the best way to communicate the board's concerns in a non-binding fashion and help them move forward with their application. But the other thing that you've already done, as I understand it, you have a technical advisory group. So that's made up of city staff who really give the applicant, the skinny on all the things that they're going to have to address in front of the planning board. So you're miles ahead of many other communities. They don't really have that capacity to do that kind of thing. That's really what I'm talking about. And as much as possible, I think when I say the duty to assist is in the public presentation process, as much as possible, direct the applicant in a fashion where they can get to yes. And so I think that's the other thing. But there's a very interesting case involving, it's Quinlan versus the town of Dover. And it's interesting because what happened was there was one planning board member against his better judgment was kind of drawn into an extended discussion with an applicant on how they could get their application approved after it had been denied once or twice. And ultimately, he did agree to sit down with the applicant and try to give him a heads up of what was wrong with his application, how we can get it approved. And later on, when it wasn't approved, he accused this member of leading down the primrose path, and he claimed that it was a denial of due process. And the interesting thing is that happened in that case is the Supreme Court said, no, wait a minute. I think this board member in good faith really was trying to assist this person. And yes, it probably wasn't a good idea for a planning board member to have an individual meeting with an applicant. But what the member did was certainly, consistent with this duty to assist the applicant, understand what the parameters of the rules were and how they might get to an approval. So I think, from my point of view, conceptual consultation is the best way to help applicants move forward and understand how they can get approval. And I really, one of the things I always encourage many of the municipalities was you can do in RSA 674-35, you can adopt an ordinance by the city council here or by the town meeting where you can require preliminary review, not just that you have as an option, but require it. You can't even get to file an application unless you do conceptual consultation. There are other forms of preliminary review. There's design review, which I understand you discussed tonight, but I think conceptual is the most flexible, and I think this is the best way to fulfill that duty to assist.
Thank you.
Okay, so this is the inventory of the major duties the planning board has. Master plan, CIP, but again, I don't know, is your CIP done by the planning board or by staff? Is it a staff-driven process?
It starts with staff, and then there's 3 members of the planning board that meet with each of the departments, and then the whole plan from the subcommittee comes to the entire planning board, and then it's sent to city council.
Excellent. I asked that because there's another mechanism which many towns have gone to where instead of the planning board driving the CIP, it's done by a committee appointed by the governing body. But that's a different manner of doing it. Now, I have up here recommend zoning ordinance amendments. I think the way it works in Portsmouth is zoning amendments come from the council. They come to you for a recommendation, but then they go back to the council for a public hearing and adoption. So you're really not quite as involved in zoning amendments as you would if you were a small town. You certainly adopt your subdivision regulations, site plan regulations. I don't know if you have a lot of excavation activity, but is your planning board the excavation regulator, or is that somebody else in town? It's not really a big issue because you may not have a lot of excavation activity under the excavation statute.
Part of DPW.
I've been involved with that in other jurisdictions. I don't think there's much of it going on here.
Okay.
There's not a planning
And then finally, the planning board also is given the authority to regulate driveways. So I don't know if you have them in your regulations, but most towns, the planning board adopts the driveway regulations, and then the Public Works Department or the Highway Department issues the driveway permits.
We have a parking, traffic, and safety department that
Right.
actually usually handles all the driveway permits.
Next slide, please. So subdivision and site plan approval, as I mentioned, I think requiring preliminary review of subdivisions, which again, you may not have a lot of subdivisions. Obviously, the idea here is you're approving divisions of land. You approve divisions of land that show new streets, and certainly that would include approvals, including utilities, et cetera. Site plan approval is obviously a different mechanism where you're approving the uses of land for multifamily and non-residential uses, so it's more than 3 dwelling units that comes under the aegis of site plan review. I would mention, I'm sure you're aware of this, the plant board can approve developments or change or expansion of uses, so anytime someone changes the use of a site plan, they might have to come back for further site plan review. I also always try to mention that the planning board or the city council can set thresholds below which you're not required to get site plan review. Now, I think there's a lot of merit for that. So if you've got a strip mall that's adding, 500 square feet of additional floor space for one of the units, do you really need site plan review? You may not. And I think that's just a judgment call. At what point is it really necessary that you have site plan review? And would you have, a de minimis waiver of site plan, given the fact that it has a de minimis impact on the public health, safety, and welfare? But the better practice is to put it in your regulations. If you're adding so many more square feet of floor space or parking or a slight modification to landscaping, you might waive site plan review because it may not be necessary. Beverly?
So just a quick question. What about exceeding the minimum standard and having a higher standard for site plan review than what the state contemplates in statute?
Well, basically,
your opinion.
any change of use or any non-residential use requires site plan review. So we really don't have a threshold that below which you don't have to get site plan review. Everything has to get site plan review. That's why I think it's a better practice to set a threshold below which site plan review is not necessary. And that's really a judgment call of what's appropriate in your particular circumstances. And I just always want to mention, because you may have it happening in your community, site plan review cannot be required for co-location or modification of personal wireless service facilities. And that's because in New Hampshire we have this statute that has, to some degree, taken a lot of the regulatory control over cell tower locations. It's RSA 12K. So I just always feel it's necessary to mention that. Next slide, please. Master plan. You have to have a master plan and have a zoning ordinance. Obviously, you've had a master plan. You've had a zoning ordinance for many years. All I would say generally about your master plan, there are 2 sections that are absolutely critical to have a zoning ordinance. It's the vision section. that articulates the desires of the citizens and guiding principles and priorities in the land use section. So you got to have those two sections in order to have a zoning ordinance. But then there are many other elements that are common. I would assume that one of the more common elements of your master plan these days might be sea floor rise, climate change, that kind of stuff, because that's kind of a topic that's going to continually be an issue for municipalities in the seacoast area to deal with their master planning process. And the other thing I would just mention is, generally speaking, although not required, the statute would suggest that master plans should be updated at least every 5 years. Now, I've known some communities that have gone 10, 15 years, which is technically not a good idea, because the longer your master plan goes out of sync with what's actually your expectations in your community, which is what the master plan is supposed to do, there's going to be difficulty saying your regulations are consistent with your master plan.
Our current one goes to 2025, so we're on the
Excellent.
cusp.
Does the state law prescribe a planning horizon for the master plan?
It just says it is recommended it be updated every 5 years, but it doesn't require it. In fact, it was a proposal a couple of years ago to require it every 5 years, and that was poo-pooed by the House of Representatives. Next slide, please. I also feel it's important to just mention the workforce housing statute. We do have a workforce housing statute, and it does impose a duty on municipalities to achieve a majority of the land areas in your community that are zoned residential must be allowing workforce housing, and the problem with the statute, it's very tricky to implement, because the workforce housing statute is defined on the price point for the housing, and the price point for the housing which is deemed affordable is based upon formulas developed by Housing and Urban Development and the New Hampshire Housing. But as indicated here, housing is affordable for those of no more than 100%, this is housing for sale, of the median income for a 4-person household for the county. So it would be Rockingham County. You would look at what is the median income, and that would define what is deemed affordable, which you take into account the cost of the mortgage and other carrying expenses and the normal expenses for a household, and you come up with an affordability number. These numbers are actually available from the New Hampshire Housing New Hampshire Housing Finance Agency, and they have a table that provides those numbers. And so it's a tricky statute, but it does have these duties, both as to housing, which is for sale, and rental housing. And I think in Rockingham County, I know that the Rockingham Planning Commission, they have typically recommended the communities have some kind of mechanism where you can provide a density bonus so that there's an additional amount of housing that might be made available in particular areas of the community, because you're going to do it on an affordable basis. And then there's the tricky part is making sure it stays affordable, and there are covenants to ensure it stays affordable. These are all tricky elements. This is not an easy statute, but you should be aware that there is legislation that I think has a potential chance to pass that would essentially say, this would certainly be of impact to the city of Portsmouth, if you have sewer and water for a parcel, you will be allowed to have 1 or 2, up to 2 more dwelling units on that parcel. So the idea is to have more infilling of units, of dwelling units, for those communities that have, sewer and water, and that certainly would be the city of Portsmouth. So that's something to keep in mind, and that would bear certainly on the workforce housing statute. Next slide, please.
Excuse me, Mr. Buckley, is
Sure.
that legislation that's going through the legislature now, that
Yes.
that 2-unit
Yes.
idea?
Yes, it is. And if I was really good, I would quote you the House bill, but I don't know those of you, since you're obviously all you're in Portsmouth as a member of the New Hampshire Municipal Association, we put out a legislative bulletin every Friday. So there'll be a Friday, this coming Friday, there'll be a legislative bulletin. So if you send an email to me, and at the end of the program, you'll have my email address, you can send an email to me. I'll make sure you'll get added to the electronic delivery of the legislative bulletin. And in there, we summarize all of the pending legislation of concern. That certainly is one of them that is pending.
And the Municipal Association actually opposes that legislation, if I understand it correctly.
Yes. it's a tricky thing for us to be floridly opposing certain of these proposals, because there's certainly pressure on the need for more housing. And sometimes we will take a position which is opposing, but not vigorously, as opposed to just very strongly opposing a project. I don't do the government affairs, so I'm not really sure how hard on the pedal we're currently working on that one, but certainly it has drawn a lot of attention, and we're currently have been testifying against that particular proposal. Because our view is zoning is a local decision, and we should not have statewide zoning. So the workforce housing statute is a form of statewide zoning. The ADU statute is a form of statewide zoning. A number of years ago, there was a statute that required every community to allow manufactured housing. That's a form of statewide zoning. We've traditionally always opposed laws that impose statewide zoning, because we think zoning is a local decision.
If you're talking about the one that would allow up to 4 units on
It's
any
the 4
residential,
units.
it's
Yes,
actually been killed.
It has been killed.
Yeah.
Well,
It's the last I heard.
I know that they're meeting tonight and tomorrow because there's crossover as of Friday, and the House has to get all of its business done tomorrow night. Otherwise, bills will die, and who knows what will happen. So we've already touched on the capital improvement program. I just would mention the CIP is not regulatory, so you really can't use it to deny an approval. It is merely designed to be budgetary recommendations to the council on what would be appropriate allocations to your capital reserve funds for future improvements. Next slide, please. I think I've already mentioned, as our understanding of your zoning amendment process, requests for the amendments to the zoning ordinance come through, I understand it here in the city, as proposals from the city council. They refer to the planning board for your consideration, but the zoning process is pretty much a council-driven way of achieving changes to your zoning ordinance, although they are required under the governing statute to hold at least one public hearing on all zoning amendments. Now, certainly, it's a lot more flexible in a city to have zoning amendments. In a town, you have to wait every year, but that's the process which is available for cities, the 675:2.
Mr. Buckley?
Go ahead.
I'm sorry, this is a generic question, but are you familiar with, is there state laws requiring public notification to every resident within a zone if you're going to change the zoning?
Yes. So it's a little complicated, but if you have, actually, I can find it. It's RSA 675:7. So it says, for instance, in 675:7, if a proposed amendment to a zoning ordinance would change a boundary of a zoning district and the change would affect 100 or fewer properties, notice of the public hearing on that amendment shall be sent by first-class mail to the owners of each affected property. So
Less than 100, then that's the cutoff?
less than 100, that's the cutoff. And then there's another one that comes in, well, I think that's the main. There's also a provision here that talks about if a proposed amendment to a zoning ordinance would change the minimum lot sizes or the permitted uses in a zoning district that includes 100 or fewer properties, notice is sent by first-class mail. So if it changes the boundary of a zoning district or changes the minimum lot sizes and it's affecting 100 or fewer properties, then there is that separate notice requirement to each of the property owners of 100 or less. So yes, that is in existence.
Okay, thank you.
Just one other thing before you leave that slide. The section of the zoning ordinance you've got up there actually does state that any proposed change to the zoning ordinance should come to the planning board, and then the planning board sends it on to council. So if, for example, there was a petition or another, say the Conservation Commission wanted to change or something like that, it could come to the planning board, or the planning board could come up with its own notion, but it has to go to council.
And I would defer to your better understanding of the city charter. I went to it quickly to try to at least accurately represent what the section was, and that was the section I found.
That's the one.
Next slide. I do always feel it important to mention the Innovative Land Use Control Statute because it's really a very unique and full of promise for communities to have innovative zoning and innovative ways in regulating uses. And there are many different ways in which the Innovative Land Use Control Ordinance operates, but it really should be seen as a way in which the planning board can be a zoning regulator. Normally, the planning board doesn't do zoning, but the Innovative Land Use Control Statute can vest the planning board with the ability to grant conditional use permits. Now, the one that I'm most familiar with, because I wrote a zoning ordinance change for a community on this issue, was a situation I recognized in the community I represented. That and this was about 20 years ago when cell tower placement was a big issue. And I noticed right away that we had this ZBA over here making decisions about whether to grant a special exception for a cell tower, and then the planning board over here granting a site plan review. And the process was cumbersome. So I said, let's just combine it together. We'll give the planning board the power to grant a conditional use permit for the cell tower, and then the planning board can combine the CUP process with site plan review. And it's a degree of administrative efficiency, bring it together in one activity and one front of one board. I don't know if you have this problem, but I've certainly seen it in planning boards and zoning boards that, the person who's the applicant goes to the zoning board and they say X, Y, and Z. And then they go to the planning board and they say A, B, and C. And it's a little bit different. And I think there's sometimes a little bit of an annoyance that, what's the information that is provided in one board is slightly different. But if you have a CUP process for some of these land use activities, it's all in front of one board. It's all right there. And you can combine your site plan review with the granting a conditional use permit. So I think, it's a wealth of potential area of regulatory efficiency, and there are a lot of different elements to the Innovative Land Use Control Statute. I would just mention that the one that I like the best for a planning board is if you decide to deny a CUP, the appeal is not to the Zoning Board of Adjustment, it's to the Superior Court. And that's how it's structured to only allow appeals to the Superior Court. So there's not a second bite at the apple at the Zoning Board of Adjustment to question a decision made by a planning board under Innovative Land Use Control. And that's designed that way to, again, I think, administratively make it more efficient in terms of how would one get a second review of what the planning board did or didn't do. Next slide. I think that I would just mention quickly, you're probably familiar with this, the planning board has a great deal of impact on public streets because you have subdivision regulations that have street design requirements, site plan design requirements. You probably, to some degree, have a great deal of impact on the decision-making if there's I'm sure, a strong relationship between the planning board and the public works department. What is the city's road construction standards? Ideally, they are, compatible with each other. The planning board also has this power to ensure at time of approval that there will be a minimum amount of improvement to a road before occupancy permits can be issued. And that could certainly be an internal road network for a large residential project which is considered under site plan review. And then, of course, it's the planning board's duty to impose performance bonding. I noticed there was questions about that today. That is part of your job when you grant the approval, obviously with the input of staff. What is the necessary amount of performance bond security to make sure the project will have sufficient financial obligation imposed to ensure all the infrastructure, public health, safety, and welfare infrastructure is built according to your specifications. Next slide, please. I mentioned driveways. A lot of planning boards don't really understand the driveway statute, but it vests the planning board with absolute control over access to public streets, and that's the planning board's ability to adopt those regulations and to require compliance. And the other thing which is interesting about the driveway statute, even if a property did not get a driveway permit from your public works department, if it has a driveway that was in existence before driveway permitting, it's still within your purview to require that driveway to be conforming in a way that it doesn't create a public health, safety, and welfare problem. It's not creating excess erosion or water being cast on the adjacent road, creating hazards to the traveling public due either to the water freezing or causing other travel problems. Next slide, please. Merged lots, I don't know if you get a lot of these, but it's a common ability that the statute permits someone to ask that two adjoining lots be merged for tax and, zoning purposes. The one thing I would mention, and you probably have this down at the staff level, but the caution I always mention about someone who comes to the town or the city to do a merger of lots is that if it's the case that one or both of the lots that are being merged are subject to a mortgage, you really have to make sure that the mortgagee has signed off and had given a consent, and the consent is recorded along with the recording of the merger document. That might, again, mainly be done by staff. Next slide, please. Next slide. I didn't mention impact fees so much. That's something that really comes under innovative land use control. But planning boards all have this authority to impose offsite exactions, which is separate and independent from the authority to have an impact fee ordinance. You might have one that requires certain traffic improvements or drainage improvements or utility improvements. But this one is very specific and targeted. So if the planning board is approving, let's say, a Walmart, and they want to put the Walmart in, you can determine that that Walmart's going to have a unique impact on either the drainage, the streets, or the sewer that is connected or would be connected to that particular private property use, and can require that the applicant pay for offsite impacts. So you can say to them, oh, well, you're going to need an XL or a decel lane, or you're going to need a traffic light. And that's the authority which is derivative of the offsite exaction statute, 674-21, Roman 5, small letter J. Next slide. I've already mentioned preliminary review. Just want to emphasize again, you can mandate it, you can put it in your regulations, but if you want to mandate it, that is, everyone has to do preliminary review or preliminary consultation. You really have to get the council to approve a requirement of that under RSA 674:35. You may already have it.
We have.
Okay,
Yeah.
and that's good, because I think that would ensure that you get that kind of preliminary consultation. I've never really dealt a lot with design review. I've only mainly dealt with preliminary conceptual consultation, which I always think is a beautiful way to flesh out what a project is, could be. I think the other thing I would say about the process is, if you get a project before they have spent all of that money on those sophisticated engineering drawings, you're much better off. I'm sure you've seen the paint expression. You say to the person, well, can we move that road 100 feet that way? And you can just see the engineers just melting in front of your eyes, because they know what that's going to mean in terms of the engineering and the drawing and the other considerations. So, you get them before they spend all that money. It's a lot easier to manage those changes in a conceptual consultation. Next slide, please.
I have a question.
Sure.
We have a historic district commission here in Portsmouth, and we have a historic district, obviously. Under innovative land use controls or design review, are you familiar with any, statutory authority for a planning board to have additional say on the massing and siting and shaping of improvements and buildings in a community?
So you're really talking about a change to an existing use that isn't going to trigger site plan review.
It would trigger site plan review.
Okay.
So, I know you can look at setbacks and you can look at lot coverage, and you can look at all those things, but what about the actual form of a building?
Oh, so what we're really talking about is aesthetics. And yes,
Potentially, yeah.
the Supreme Court has made clear that there is a realm of authority that attaches to the ability of the planning board to regulate aesthetics. So there's a case, I can't remember the name of it. It involved someone who, I'm sure you've seen them before, the large retail outlet that sells campers, and they always want to put up a flag 500 feet tall with a huge flag on it. Okay, there was one of those in Tilton, and the planning board said, that's not going to fit. You can put up a flag, you can put up a pole, but not that big. And of course, they claimed that was an invasion of their First Amendment rights, et cetera. But it was based upon the inherent ability of the planning board to require, that the use aesthetically be consistent with the neighborhood. Now, it's probably better to put it in your regulations, but the power to impose some aesthetic standards, architectural standards, that's certainly within the realm of the planning board's ability to regulate. And I think, again, probably better to have it in your regulations, architectural requirements and, how things would appear, that kind of thing.
Thank you.
Next slide, please. Again, this is the balance of the presentation is kind of the process, and this is probably very familiar to you. There's a thing called a completed application, which has to be done at a public meeting. I don't know how you do it here. When I was on the planning board, the planner came in, the planner went through the checklist, and then when the planner came to the public meeting, we would say, Bill Clubbin was our planner. Bill, is it a completed application? And he'd say, yep, and we'd say, fine, let's vote that it's complete. And then we would move into the approval process. But once you've done the completed application process, you are then within a timeline to get the project approved. Next slide, please. And that timeline is 65 days from the date of plan acceptance. It's not a lot of time. So the reality is you might have to front load, especially if you've done preliminary consultation, some of the review stuff that you need. I think in terms of, a very complicated project, my experience has always been when you're dealing with that 65-day deadline, most applicants, if they feel you're working with them, are prepared to give you more time. And that's really kind of, when you do that, make sure it's in writing. So if at the hearing, you're bumping up against 65 days and the applicant, and you look at the applicant and say, well, we need some more time, that you just have a piece of paper you can whip out and say, here's your consent to give us another 30 or 60 days. The other approach to that is to say, well, we can take up the application tonight and either grant approval or not approval. If you would prefer us to say no, we can certainly do that and facilitate this process. And most of the time, if they're willing to work with you and you're working with them, they're going to give you more time. So I guess that's the main thing I would just mention about the 65 days. It can be a give and take process.
So
Yes.
what about when the board may vote to postpone an application because of insufficient information or something like that?
Postpone. All right. So that's not a statutory, concept. The only analogy that I can say is there is a case that says if the board has said you have to meet this requirement and you're not meeting that requirement, the board can say no. So when I was handling for a planning board an application where we required the applicant to pay for an engineering review to decide whether they had a fair share of their approval of a road, and they didn't pay it on time. We sent them a letter saying, you've got to pay X dollars by this date before we can continue, and they didn't pay it. We brought it up I said, Madam Chair, I think you ought to bring this up and say we're going to deny your approval for noncompliance with the board regulations and the necessity for paying for the cost of the engineering review. And they immediately no, that's all right, we'll pay you, and we got it taken care of. So I know you can do that. But just to postpone, I think.
So you have to get consent from the.
You can get consent, but you want to get it in
They ask
writing.
them
But,
for-
you still have to deal with that 65-day deadline. And the better approach is to get it, done in writing so it's clear you've been given an extra 30 or 60 days, whatever the case may be.
Okay.
Next slide, please. You kind of already have this. This is a slide I mainly use for smaller communities. As I understand it, I don't know if you've done this, but there is a mechanism where the city council can delegate to a subcommittee of staff minor site plans. And that way you can do a minor site plan approved process, which can allow for someone to appeal a denial of a minor site plan to the planning board. So there's a mechanism for that. You already have a technical review group. It's excellent. You've got staff involved in meeting with the applicant to know what they're going to be facing. And then I've already mentioned thresholds, that you can establish thresholds below which site plan review is not necessary. Next slide, please. Acceptance vesting is an important concept that I always want to emphasize to planning boards. The idea behind acceptance vesting is when the plan is deemed complete, the regulations in effect at that time are the regulations that apply to this project. So if at plan acceptance, the regulations said X, but 3 months later, the regulations are modified, it's the regulations in effect at the time of plan acceptance which are material and binding for that application. And that's the concept between acceptance vesting. So when you accept, you're accepting with the understanding that the regulations you have in effect then, whether zoning or site plan or subdivision, those are the ones which will be binding on this application. And if the rules change, the changed rules will not apply to that accepted application. And that's part of the reason why it's important to be understanding. There is this ability or this protection against changes in the rules while the application is pending before the board. Next slide, please. I also put in these slides about developments of regional impact. I don't know how often you have this circumstance, but obviously it's something where you would work closely with your regional planning commission. So anytime a project is reasonably expected to impact a neighboring community because of size, proximity, transportation networks, aquifers or surface waters that could be affected, the duty of your board, and that could also apply to the building inspector and the zoning board of adjustment, is to say it's a development of regional impact, and we're going to give notice to the abutting community and the regional planning commission so that they can participate and have the status of abutters. Next slide. So you have to provide timely notice to the affected communities. You have to allow the RPC potentially affected municipalities to furnish timely input, and it encouraged planning board members really to consider the interests of others outside your community when a project near a border or having an impact on a community bears meriting the point of view of your neighboring community and the regional planning commission. Next slide, please. So your obligation is to review it promptly and determine whether or not a development could be construed as one having a regional impact, and doubt concerning regional impact is supposed to be resolved in a determination that the development has a potential regional impact. I would just mention there was one case involving a shooting, a gun activity in the town of Warner. And so what's important to know about the development of regional impact statute is that in that particular instance, the planning board decided it didn't have a regional impact, even though it was right next to the adjoining community of town of Hopkinton. But when the case was appealed to Superior Court, the Superior Court judge said failure to properly take these standards and find a development of regional impact would result in the case being thrown back to the planning board because you didn't appropriately find a regional impact was in existence. So it's something to keep in mind. It could result in a decision being reversed and sent back to the planning board. Next slide, please. So the procedure you're supposed to follow is within 5 days at which a DRA determination is made. So you decide that, I think that probably the better practice is that plan acceptance or maybe even conceptual consultation, make some kind of preliminary judgment. It is a development of regional impact, so that as quickly as possible you can notify the affected community and the regional planning commission. And then you have to then submit a copy of the development plans to the regional planning commission so the regional planning commission can do its job and give an assessment of the regional impact. And then 14 days for any public hearing, you have to notify by certified mail the affected community and the RPC, so again, that they can participate in the process. Next slide, please. And luckily, the statute was amended last year to give you an additional 30 days on the 65-day deadline if it is a development of regional impact, because we recognize that there's a lot of steps built into the DRI statute. So it was decided last year by the legislature to give planning boards an additional 30 days for review, added on to the 65 days. Next slide, please. And then this is just some new statutes which I think are worthy of your attention. And I know there was a discussion about this, doing third-party review of construction of improvements approved by the planning board. There's this new statute that requires the city, if you're going to have a separate engineering firm to review construction of infrastructure that was approved by the planning board, you're supposed to develop a scope for the inspection, or alternatively, and I don't think this is a great idea, allow a signed certificate from the site plan designer in lieu of inspection. I'm not sure if there are many towns that go that route, allow them to do that, but okay, you know, if an engineer is prepared to put their stamp on a plan saying it's been done according to the requirements, that might be sufficient. I'm not going to make a judge here, but I would think separate inspection would be appropriate. Then there's also this requirement, this new requirement that says you can't adopt a regulation that prevents a person from installing a safe and commercially available heating or energy system of their choice. These are just amendments to some of these statutes. Next slide, please. You have probably been through a lot of public hearings. Just always important to mention that of the public hearing process, by statute, you're required to hear from the applicant, abutters, and others with direct interest, and others as permitted by the board. Now, others with direct interest would mean someone who could say, this project will affect me or my property. And then others as permitted by the board would be anyone else in the community. So I think the first three, you really have an obligation to hear from: abutters, applicant, and those with a direct interest. I would assume you probably have, because RSA 676:1 says the planning board has to have rules of procedure. You follow the rules of procedure. Site visits are public meetings. I've always been of the opinion, we still do it with our zoning board of adjustment. I did it when I was in the planning board. Site visits are public meetings. We give notice to the abutters. We all go, and it's kind of a gang meeting. We stand out in the mud or in the rain or just a bright sunny day, and we talk with the applicant. What are you proposing? And then we come up with a short report, which is provided at the public hearing process. And I mentioned Riggins rules. I don't know how many of you have ever read the Riggins rules, but there are a wonderful set of wise little observations from Fred Riggins, who was for many years the chairman of the Phoenix Planning Commission. And they're really excellent ways in which understanding your role as a planning board member. Next slide, please. Now, when you're doing the deliberation process, it's a couple of things one has to keep in mind. Get all the information you need before you close the public hearing. And avoid ex parte contact with parties while you're in the deliberation process. So if you've closed the public hearing, but you're not going to conclude the decision-making process that night, you're going to come back another night, really avoid having ex parte contact. The board can rely on your personal knowledge of information that you are aware of that bears on your decision-making. And you're not bound to accept the conclusions of experts. However, if all of the experts say you can't do this, you can't do it. And I think that the Condoleezza case is the most best example of what you can't do. And so I always mention Condoleezza because it involved the town of Conway being asked to approve a project that had one means of ingress to, I think it was like a 35 or 40 subdivision. A subdivision of subdivided lots. And the planning board was convinced that one ingress in was insufficient. They wanted another road on the back end, another 500-foot road that would provide a different means of ingress and egress. The applicant's engineer said you don't need it. The planning board's consulting engineer said they don't need it. The Public Works Department said you don't need it. And then the planning board said, we don't care. We want a second means of egress. The Supreme Court said, you can't do that. You can't make a decision that ignores the uncontradicted expert testimony. And it doesn't mean you have to accept what the experts say, but if it's uncontradicted, you're going to have a hard time saying no, or going contrary to that expert opinion. Next slide, please. The Dartmouth and versus Hanover case is also a key one that one has to be mindful of. Because if you may know anything about the case, Dartmouth was building a brand new super duper athletic center, and the super duper athletic center, in the opinion of the planning board, was going to cast a shadow across the a road to the nearby abutters and make their lives miserable. And the planning board based its decision on that, among other things. Notwithstanding the fact that, and I'm amazed you can get an expert on anything, Dartmouth was able to get an expert on shadows. You know, they had a shadow thing that showed, no, there's not going to be a shadow on these houses. And the planning board members said, we don't care, we're going to say no. And I think the key thing for the court of concern, and I think it's one that is where planning boards can be challenged in making decisions, the court observed that the staff had demonstrated that the project had met all of the checkbox requirements, comply with all the zoning requirements. But nevertheless, the planning board said, no, we're not going to approve it. And what the court said, that the planning board ultimately was relying on its personal feelings, and they had engaged in ad hoc decision-making that was out of harmony with the town and its environs. And so when the planning board did that, it deviated from the duty the board had to stick to the rules and regulations and not to, as the court said, rely upon lay opinions and anecdotes. So, but the other thing which is true, which the court also says in this case, and it can be bedeviling, the court said, we're not saying simply because a project satisfies all the requirements of the regulations that a planning board must approve, but we are saying if you're going to say no, you have to have a sound basis for doing so. You have to have something within your regulations or some other basis to say no. So, I think for you, as a member of the planning board, if staff said, hey, this project complies with all the requirements, we don't see any issues why it shouldn't be approved, you better have a really sound reason why it should be denied. Because if you are in that area, like the Dartmouth-Hanover case, it may turn out that the court would, a reviewing court would say, wait a minute, these are based on personal feelings, and that's ad hoc decision-making, and that's not appropriate. Next slide. Not a terribly big surprise. You have to have a written decision. The statutes require you have to have a written decision. The decision has to either to be approved with conditions, or disapprove. By the way, and this is something certainly is an issue for smaller communities. There are many communities that think if we just say no, we're not going to approve, that's enough. You can never just say no. You have to say no, we're not approving this project for the following reasons. Because the applicant has a right to know what are the reasons why I've been denied, and how I can use what you've said why I've been denied to come back with a revised plan. So just saying no doesn't work. You've got to say, no, this is the reason why we're not giving an approval. And by the way, a tie vote is not a decision. If you have a tie vote, you got to stop and try again and get a vote that is either approval or denial based upon a decision that's no longer a tie.
Mr. Buck, I think in Portsmouth, we have rules that address tie votes that I don't know, I can't speak knowledgeably, but I know that we have had tie votes, and it was a standing decision, and it either went forward or it didn't.
Well, a tie vote is not a decision, because it either from basic meeting protocols, or I would assume your rules of procedure, a tie vote is nothing. It is either approval or denial. So it's like a jury. Somebody has to change their mind. Yeah, I've told this to a number of boards before. If you have a tie vote, you've got to stop and figure out a vote that can get a majority of the members to either approve or deny. That's just a requirement. And tie votes that's no decision.
Can anyone on the board back me up on this?
I thought it was a no.
I never had, in my 9 years on the planning board, I've never had a tie vote, so I can't speak from experience. I was under the impression it's a no if it's a tie vote, but I don't know where I get that from. Maybe our city attorney knows off the top of his head.
I would probably turn to Robert's Rules of Order, but I think there's something in Robert's Rules on that. But
a tie vote, the motion fails, but I agree with Attorney Buckley. In my experience, it doesn't work. You have to vote to approve, deny, or approve with conditions. Those are your three options, and a tie vote doesn't do it. Now, the ZBA has different rules about some of their appeal processes, that when an appeal can happen based on a tie vote. That's not us. So I'm not.
Okay, so there's never been a 3-3 or 4-4 vote on the planning board?
Not in my time.
Okay.
And not that I recall.
Maybe I'm thinking zoning board then.
Well, the zoning board, if the zoning board is going to take action, it has to have 3 concurrent votes. That's required. And zoning boards are always 5 members, so you would always have the majority of the members voting either approval or denial. Next slide, please. Yeah, familiar set of things in describing how you grant approvals. First thing I would say, and I've seen planning boards think this is true, if an applicant makes a representation which is recorded in the minutes, it's not binding unless it's made into a condition of approval. And I can't tell you how many times I've had a planning board say, well, they said they were going to put in a tot lot, and it's not there. And I said, did you put it in a condition of approval? No, it's in the minutes. And I said, that doesn't count. Don't rely on the minutes. Get it in as a condition. And the conditions have to relate to the relevant criteria. You can have standard conditions. The towns that I've represented, we had developed a template of standard set of conditions. So there was a standard set of conditions, and then there were customized conditions for that particular project, and those were always together in one notice of decision. You can have conditions precedent, that is, we're not going to sign the plan until you get these supplemental pieces of information for us, and that's a condition precedent. Condition subsequent, that this project is approved, but you can't have garbage pickup after 11 o'clock at night, or whatever the case may be. And then you could also have a circumstance where you've approved it subject to some kind of important professional input. We want to have a final engineering report on your changed driveway location. That cannot be approved in final form until you have what we call a SCLAR hearing. You have to have a subsequent hearing, because to rely upon that report just requires discretionary judgment, and you require to have a public hearing to go over that supplemental engineering report in order to reach a sound decision. Next slide. I mentioned grandfather rights because they're important, because we have a statute, 674-39, that says if you get approval and begin active substantial development within 24 months and substantially complete improvements within 5 years, you're absolutely vested from any changes in zoning and subdivision regulations. And it's vesting, and it kind of ties back to that acceptance vesting thing I mentioned before. They can't change the rules on your plan because you've made substantial improvements. But one of the things you can do as part of your approval is say, this is the quantum of work you must do within the first 24 months. Now, it has to be a reasonable amount of work, but you've got to indicate it in the approval. Now, if you don't put it in the approval, this is how much work you must do within the first 24 months, then any amount of work is going to be sufficient. So it's important to express that in the notice of decision. And it's also important to express what would be considered substantial completion of improvements. Something off 50% of the work in buildings probably is somewhere within that range would be considered substantial completion of improvements. One interesting thing about the statute is 674-39, if you had changed your impact fees, a change in impact fees is not subject to the grandfathering statute. That was actually, I'm proud to say, a participant in getting that amendment in there, because we recognize there could be a need to change impact fee amounts. It could certainly be due to inflation, certainly more so today than ever. And then finally, next slide. I've got 2 slides here about appeals. So if people are aggrieved by your decision, they can appeal to Superior Court, but now they can appeal to the Housing Appeals Board. But the question that would have to be appealed has to deal with questions of housing and housing development if they want to go to the Housing Appeals Board. Sort of like those who are familiar with the abatement appeal process, you can go either to Superior Court or to the Board of Tax and Land Appeals. Same thing here. You can go to Superior Court to appeal the denial of the site plan or appeal the conditions, or you can go to the Housing Appeals Board if it involves questions of housing and housing development. And I think there has been some concern that the Housing Appeals Board kind of went a little far afield. There was an important decision that overturned a layout decision by the Select Board in Pembroke. So it wasn't actually a decision about housing at all. It was just whether or not the Select Board would agree to change a Class 6 road to Class 5. and it really wasn't a land use decision, but the Housing Appeal Board took the case and reversed the decision of the Pembroke Select Board. There is a proposal to rein in the degree of authority of the Housing Appeals Board, to limit their authority to just decisions by the Zoning Board of Adjustment and the Planning Board, not selectmen, not Historic District Commission, et cetera. We'll see where that goes, but be aware, and those decisions come really quickly. They are really, they churn through, and their website now has a pretty good inventory of the cases and the decisions, and they're instructive on a number of different areas, and we're trying to keep up on those decisions, so can we record them in our court update summaries. And then ultimately, if they don't go to the Housing Appeals Board, next slide, they can go to Superior Court. Now, everyone has different experiences with Superior Court. I'll tell you, my experience is, I always tell planning boards this, you have no burden of proof. You don't have to prove what you did was correct. The other side has to prove that what you did was illegal or unreasonable. So the most important thing for a planning board in front of the Superior Court is to get as much information, as much paper, all the emails, every report, every shred of evidence you could possibly get, because the board only has to show there was evidence in the record that supports the board's decision. And there's no trial, it's just on the record in front of a Superior Court judge. And, I don't know, they're all going to be mostly in Rockingham County, so it may somewhat depend upon the judges in Rockingham County at that particular time. But frankly, I always had a pretty good track record in winning these appeals, but, it depends on the case, it depends on the circumstances. And so that's Superior Court appeal. And with that, I'm at the end and happy to answer questions you might have above and beyond either the materials I've discussed already or any other issues that is on your mind.
Anybody? I guess it was a very comprehensive presentation.
Thank you. They're all just stunned.
Thank you very much.
Oh, actually, wait, I was waiting, but I'll just go. I have a question about developments of regional impact, and you probably know that we have Pease Development Authority as part of Portsmouth, and there's a airport expansion contemplated here, but I'm not going to talk about that. But I was just curious. It's a unique setup over there as far as the PDA, and the best way is explained to me is that it's not state property, it's not local property, it's PDA property. It's a separate entity with its own fiefdom, for lack of a better word, and that maybe best is a Native American reservation. It's kind of out there, but they run their own show. And to that end, is it true that Portsmouth Planning or Zoning has no say on what goes out at the PDA?
Well, what I can tell you is that RSA 674-54 incorporates the zoning and regulatory immunity enjoyed by governmental uses. So generally it is recognized, and this is derived from case law, that a town is not subject to its own zoning ordinance. The county is not subject to the zoning ordinance of a town, et cetera, et cetera. A school district is not subject to the town zoning ordinance. Those things are true, and so from that case law, the legislature put in RSA 674-54. Now, I can't tell you, because I've not researched the issue, does that zoning and land use regulatory immunity, is that enjoyed by an entity created by the state of New Hampshire called Pease Development Authority? I don't know off the top of my head.
The answer is yes.
Okay.
I've been a tenant out there for 27 years, and I've been getting these calls every day since then. Pease Development Authority zoning ordinance, site plan regulations, and subdivision regulations, originally adopted December 20th, 1991, most recently revised October 15th, 2020. They have their own inspection and engineering department. It's irritating, but...
They do actually come before planning board, but the only thing we're allowed to do is review the project and send recommendations to Pease.
And you see, and that's consistent with RSA 674-54, which is the governmental use, land uses. So typically, you know, like the school district would, as a courtesy, they're required to tell you they're going to enlarge the high school and the changes, but they're not required, and you can provide them comments, but the comments aren't binding. And I think P's would fall into that category, but they're not listed in the statute. But it does say that the state enjoys that immunity from local land use regulation, and I think P's would be deemed an arm of the state of New Hampshire. But I've not really studied it, so I'm leery to pontificate that that's true, but I think it's true.
But your point, Jim, I think is very interesting, because I think it would be incumbent upon the Pease Development Authority Engineering Department to recognize it as a regional, because half of the base is in Newington. You got Ryports with Newington, Dover, Durham, involved in that noise issue.
Right, yes. So,
It's regional.
That's regional.
But Pease has to actually state that, right? They have to out loud, I happen to sit on the Regional Impact Committee for the Rockingham Planning Commission. In fact, I have a meeting at 9 a.m. tomorrow for a project in Brentwood. So the actual body has to, just like we as a planning board would have to declare it a regional impact, Pease Development Authority would have to make that request. We could obviously suggest it to them and make a recommendation, but they don't have to take it, just like our approvals.
Right, and I can't speak to, does Pease have this zoning and regulatory authority, and are they subject to the DRI statute? I just don't know. It could be true, but it sounds like what has been happening is Pease comes to your board and say, this is what we're planning to do, what are your thoughts? And then they listen to you, and then they may or may not incorporate your concerns, but they may not be required to.
There's a separate statute, it's 12G, that applies to Pease, and I asked Attorney Buckley about this, and I don't want to drag him into this because it's not, he didn't research it, and I don't think it's fair to ask him too much about that tonight. Anything else about what he did present? And we can talk about Pease, at a later time or after he's done. I don't want to keep him.
Chairman, I was just going to make one comment that, this pertains to when McIntyre was kind of, a lot of the different listening groups and everything else were all getting involved in everything else. But Attorney Sullivan sent out an email to everybody on the board just stating, this is the role of the board, and these groups, just trying to direct us, or not direct us, but give us guidance as to participating or not participating in these groups and so on and so forth, and how that could affect anything that comes before us down the road. So I just want to say thank you, Attorney Sullivan. That was helpful in that time frame, so I appreciate it.
Okay.
So,
You know what that was about?
Sort of, but not really.
Okay.
yeah, sorry, I was just a statement. It was just
Okay,
Thank you very much.
Thank you very much.
Thank you.
We
Thank you.
appreciate it.
all right.
Very helpful. Does the board have any board conversations?
Just want to go to the bathroom.
What was that, Beth?
Just want to go to the bathroom.
Do you want a break, or are we done for the evening?
I'm done, unless
we
somebody
done?
else has something else to talk about.
2 hours, I think we're good.
Yeah, I mean, there's a little bit of time, but I'm ready to wrap it up if it's whatever the board wants. So if somebody wants to make a motion to adjourn, we can adjourn. If someone wants a break, we'll
I
take
make a
break.
motion, we adjourn.
I'll second that.
Any discussion? All those in favor?
Aye.
Aye.
We are adjourned.
Thank you.
Yay, thank you.